Just please give me a chance, man. I promise I'll be in court next time.
I've been promised that many, many times, Mr. Weedle, and a lot of people don't follow through on their promises.
I just have a grandson. Can I please go home, man? If you give me OR bond, please. The only reason why I pled guilty was because he told me to. He said I was going to get probation, and that's why I wanted to get it over with. I didn't think I was going to plead guilty to prison.
This time, the court will call State of Kansas versus Christopher Gene Weedle. It's case number 2025 CR 324. Brett Sweeney appears for the state of Kansas. James Watts is defense counsel. Mr. Weedle from the jail's Zoom location. There's an interesting history to this case. Mr. Weedle had pled guilty to theft after a prior conviction, a level 9 felony, back on December the 5th. Court ordered a pre-sentence report be completed and sentencing set for February 2. However, notes from February 2 indicate the defendant failed to appear for his sentencing. The court ordered bond forfeiture, bench warrant, with a no bond hold due to his failure to appear. And he's made a subsequent court appearance before Judge Crum, setting today's date. So, Mr. Watts, what statement would you make regarding this case at this time?
Well, Your Honor, this case is set for sentencing. I had previously filed a motion to depart dated January 30 for what we'd anticipated would be a sentencing in early February. As Your Honor's noted, he failed to appear at that time, but I am prepared to proceed to sentencing if the state wishes to do that this afternoon.
Mr. Sweeney?
Your Honor, I hadn't anticipated the same. However, and quite frankly, Your Honor, I don't know if I'm checking the victim notice letter. Our victim notice letter sent out notification of today's date as a preliminary control hearing and not as a sentencing. So out of an abundance of caution, I would ask that we continue the sentencing. So if those individuals or individual wanted to appear, they could at a sentencing and not at a preliminary control hearing.
Yes, and we're only in this situation because Mr. Weedle didn't appear for his original sentencing date. All right, court's going to acquiesce in the state's position here and reset this. How much time realistically do you need to have your office send out a letter or other communication to the victims in this case to give them an opportunity to appear?
Probably a couple weeks.
Oh man, Connor, can I say something?
Yes.
I didn't mean to miss court. I promise. I've never missed a court date before. Title Max took my truck, and I'm sorry that I missed court. You know what I'm saying? I just have a grandson. Can I please go home, man? I promise I'll be in your court. I've never missed a court date before in my life, and I'm not about to start now. I have a grandson I haven't met yet, and my family needs me. Just please give me a chance, man. I promise I'll be in court next time.
I've been promised that many, many times, Mr. Weedle, and a lot of people don't follow through on their promises.
Yeah, but not by me, Your Honor. I promise I'll be there. I got to report to my corrections officer and stuff. My corrections officer is Casey Ottawilliam. They redid my corrections or whatever, and I need to report to her. And her name's Casey Ottawilliam. I mean, so I'm not going nowhere. And I promise you on everything, I'll be here. I've never missed a court date before. I want to go home, be with my family, meet my grandson, and just go back to work and start doing what's right. You know what I'm saying? Just please give me an opportunity. And I'm sorry I missed court. Like I said, Title Max took my truck for $30 in late fees. I did not intend on missing court. I promise I didn't.
Did you call somebody and let them know your situation?
I talked to Mr. Watts the night before and asked him if he can get a continuance and stuff. And you know, I tried to find a ride. I promise I did. But if you give me
It's just that all this took place back in February, early February, and now we're in the middle of April.
I know. I've been in jail for 2 months, Your Honor.
Where were you in jail at?
In Sedgwick County. They reinstated my corrections on the 19th of March, and then I came here. So, but I've been locked up since February 23rd, 2 months. I promise if you give me a chance to go home, Your Honor, I promise on everything I love, I'll be in court. My son has a vehicle now, my daughter has a vehicle, and my wife, all three have vehicles now. So I just want to go meet my grandson and go back to work and start doing what's right, Your Honor, please. I'm too old for this.
There are days I say the same thing, Mr. Weedle.
I understand, Your Honor, but I'm having a really hard time. I really am. Please give me the opportunity to go home. All my family's watching right now on Zoom. And if you give me the opportunity, I promise you, I will be in court. I promise you.
Mr. Sweeney, can your office use its resources, email, telephone calls to notify the victims of this new date that we're going to set?
Yes, Your Honor. I think that we could probably do that.
I understand the request for 2 weeks. I'm going to address my assistant for a moment. I would appear to have Monday, April 27 at 4 o'clock still open. Mandy?
Yes, Judge, it's open.
All right. I'll move the Weedle sentencing to next Monday, April 27, 4 o'clock. Appreciate the efforts of the county attorney's office to do some sort of personalized notice to the victim in this case to give him an opportunity to appear. This will be done by Zoom. Monday, April 27, 4 o'clock.
Is there any way I can
And
get like,
hopefully, Mr. Watts, you'll free up from your docket responsibilities by 4.
Probably, Your Honor. Yes, sir.
Okay.
He's
Mr. Weedle, I've considered your request for a release between now and time of sentencing. You very well may be honestly addressing the court. I am looking back at February, though, and you missed on February 2nd. You didn't go into custody until the 23rd, and yet no arrangements were made for rescheduling of your sentencing during those weeks.
That's because the my corrections, I violated my corrections because I couldn't report to the meetings and stuff too. That's all due to a ride. You know what I'm saying? Your Honor, I understand your concerns, but I promise if you give me opportunity, I swear I'll be here. I'll be here next Monday, I promise. If you give me OR bond, please. I just want to go meet my grandson and go back to work. I promise I'll be here.
Okay. There is a second factor which this court has considered, which it needs to place on the record. Mr. Weedle, according to the pre-sentence report, you're presumptive prison here. You're not
Yes, sir.
presumptive probation. You're presumptive prison. So the presumption before the court at time of sentencing is you're going to prison.
I am.
Increases the run risk possibility anytime
I'm not
somebody's
running.
facing prison.
I'm from here. I'm from Butler County. I went to
Yes.
school, Oil Hill, and everything else. I'm not going anywhere.
I understand your passion and your concern for your family due to the no bond hold order currently in effect. The court believes that's the most appropriate order to maintain for the next week. I've given you the only setting I have for what appears to be weeks, Mr. Weedle. I've tried to expedite the rescheduling and asked the attorneys to accommodate it. So I'll see you 4 o'clock, April 27, but will not grant any relief at this time from the no bond hold order.
Can I get a bond?
No.
Okay.
That is a direct consequence of not appearing in court, Mr. Weedle.
I'm
So
sorry.
April 27th at 4, we'll take up sentencing in the matter at that time.
All right.
The Weedle matters in recess. State of Kansas versus Christopher Gene Weedle. It's case number 2025 CR 324. The defendant appears from the Butler County Detention Center's Zoom location. James Watts is defense counsel. Amber Norris on behalf of the state of Kansas. This matter comes before the court at this time for sentencing. The defendant had entered a guilty plea to theft after prior conviction, a level 9 felony back on December the 5th of 2025. Sentencing originally set for February 2nd of 2026. The defendant failed to appear for sentencing. Court issued a no bond hold order as part of bond forfeiture and a bench warrant issuance. The defendant was eventually picked up and sentencing subsequently scheduled for today. The court has received a pre-sentence investigation report that was prepared by Chastity Altus from the Court Services Department. She's not with us today. However, Chief CSO Sarah Wheeler is present on the meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first, is there any objection to the criminal history which is stated in this report?
No objection, Your Honor.
Any objection from the defense, Mr. Watts?
Your Honor, I have reviewed the criminal history with my client. We believe it is accurate, have no objections.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score C, and the court will proceed further accordingly. Ms. Norris, do you know of any legal reason why sentence should not be pronounced in the Weedle case here this morning?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir.
Mr. Weedle, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing here today?
No, sir.
We'll proceed further then. Counsel, I am aware that there is a sentencing related motion that needs to be considered by the court. The defense has filed a motion for a departure sentence in this case. It is entitled motion for dispositional / durational departure. You may proceed further in regards to that motion, Mr. Watts.
Thank you, Your Honor. First, Your Honor, we'd ask the court to consider that Mr. Weedle resolve this matter on a relatively quickly basis. We had an initial appearance on October 6th. He waived the prelim at that time. The following appearance in December, there was a entry plea on this matter. So this is not something he has denied. He entered a plea on this matter and resolved it quickly and accepted responsibility on it. What's interesting about Mr. Weedle's case is since that time, and I'll point out the PSI doesn't talk about any prior or anything that he is currently on probation for at this time. However, I will also note that same PSI speaks to 4 cases in Sedgwick County, theft, much like this case, in Sedgwick County on September 5 of 2025. My client believes it's important, and I think it does matter, that those incidents took place. Let me try to get my notes correctly. Those cases happened after this one. He was not on probation or parole or any sort of supervision at the time this took place. And they further don't really contribute to his criminal history score. So his criminal history score was C at that time as well. The Sedgwick County Court, nonetheless, decided to place him on probation in those cases. He is on supervision in those cases and is ready to go forward on probation in those cases. He has supervision not only in this case, but in 4 cases out of Sedgwick County. Frankly, I do not know whether those cases are concurrent or consecutive to this one. Actually, as I think about it, they would not have a designation because this sentencing would come second. This case could be consecutive or concurrent with those. That would be at the court's discretion. Because he has ample supervision in this case, we would ask the court to consider placing on probation in this case as well, so that he can finish not only this case, but his Sedgwick County cases. Now, I would note, and Mr. Weedle believes, and we kind of have a disagreement about this, but I think it's important to point out, this case is not a theft in the traditional sense, and that anyone was accosted or he broke into anything, took what was clearly someone else's. This is a case involving a cell phone sitting on a park bench outside the jail where he picked up and took to his own. Ultimately, as he's acknowledged, kept it himself. But this is not a case where he took it from anyone or was known to be anyone's. This is essentially a case of not making any efforts to return lost property, rather than a traditional sense, a theft in the traditional sense. And I think that is a difference. That makes a difference. So for all those reasons, Your Honor, we'd ask to consider a probation in this case. He is going to be amply supervised, not only in this case, but in Sedgwick County as well.
Can I speak, Your Honor?
I'll give you the opportunity later, Mr. Weedle.
Thank you, sir.
All right, Ms. Norris, what is the state's position regarding the departure request in this case?
Your Honor, state takes no position regarding or makes no argument regarding the departure, whether in support of or in argument against. Our agreement was the state would recommend the low end of the box, the presumption, and not argue one way or the other regarding the departure.
Very well.
And that's our understanding as well, Your Honor. The state would stand silent on the departure.
Mr. Weedle, your attorney has already made a presentation in regards to the departure request. I will allow you to make a statement later.
Okay, thank you, Your Honor.
All right. Are there any victims and members of a victim's family present who desires to address the court in relation to the Weedle sentencing? Court finds no such persons present. So at this time, the court will ask for recommendations from counsel regarding an appropriate sentence for Mr. Weedle, beginning with Amber Norris on behalf of the state.
Thank you, Your Honor. Your Honor, the defendant falls as a C on the grid, as previously noted. The mitigated sentence regarding count 1 is 11 months in the Department of Corrections. Your Honor, he does have which makes him presumptive prison based on the special rule 29, where he has previous thefts, burglaries, or aggravated burglaries in his history. Your Honor, defendant can earn up to 20% good time credit, or would be or could be subject to 12 months post release. Defendant has earned, as of today's date, 26 days of jail time credit. Your Honor, would ask the court assess the cost of the action to the defendant. Court will need to address court-appointed attorney's fees and the bid's application fee. There is not a request for restitution. Based on defendant's criminal history, the court will not need to address DNA database fee, etc. I don't believe state has any further recommendations for the court at this time.
Very well. Specific recommendations for an appropriate sentence, Mr. Watts?
Your Honor, pursuant to plea agreement, we'd ask the court order the mitigated sentence of 11 months in the Department of Corrections with the good time and post-release as noted. For reasons previously argued, we'd ask the court to consider a departure to probation in this matter. As we noted, the state standing silent on that. I'm not going to re-argue those factors again. Nothing else, Your Honor. Thank you.
Very well, Mr. Watts. At this time, the court will address the defendant, Christopher Gene Weedle, personally, and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court. Mr. Weedle?
Yes, Your Honor. First off, I want to say that I'm sorry for all this. I never meant for this to happen. When I found the cell phone outside, the cameras can view that I brought it in, and I was trying to go through it to find out whose it was to return it to the owner. I wrote Mrs. Ware an apology letter since then and told her that I was sorry about everything. I'd never meant for this to happen. I wanted to return it to the person, whoever it belonged to, and I'm glad she got her cell phone back. But that was my intentions the whole time when I found it, because it was just sitting outside, and I brought it in and was seeing if it was unlocked to try to return it to the owner because my son was coming to get me. Nobody ever tried contacting that phone or texting it because I kept it charged and in my nightstand for 4 months, Your Honor, and nobody ever I didn't sell it to somebody on the streets. And I sold it to Eco ATM when we got kicked out of the motel. And that's the case that I'm fighting. I got court May 6th for that, for selling it in Wichita, Your Honor. So I got court May 6th for that. So I just asked, please just let me go be with my family. I never meant for this to happen. I haven't been in trouble in Butler County in over 10 years. I've always did my probation and everything. So I just asked you, please just let me go meet my grandson I haven't met yet, be with my family. And I promise, Your Honor, you'll never see me back for you again. Thank you.
Very well. Thank you, Mr. Weedle. The court will pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of felony theft, a severity level 9, non-drug, non-person felony, in which the defendant has a criminal history score of C, thus placing him in grid box 9C. The court hereby sentences the defendant to a term of 11 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court has considered but declines to impose a fine in this particular case.
So I'm going to prison then?
Chris?
Is it all right if I go ahead and complete
Yes, yes.
my announcement of your sentence, Mr. Weedle?
Yes, sir.
The court notes that in grid box 9C, this would be ordinarily a presumptive probation case. I will note the application of a special rule. This is a felony theft with 3 or more prior convictions for a felony theft, burglary, or aggravated burglary. This court will just simply note from the criminal history, this connotes that this defendant has at least 10 prior felony theft convictions, 2 prior burglary convictions, and here he's before the court again on yet another felony theft case. The court does find that with the special rule application, this is a presumptive prison crime under Kansas law. The court notes that there's been a motion for a departure sentence filed by the defense in this case. The court has considered the reasons behind that departure motion, that he accepted responsibility early in the case. Court notes that there is the implication of other cases. The court has considered that. And then the circumstances of the crime itself. However, the court does not find that there are substantial and compelling reasons that would support a departure sentence in this case. And Mr. Weedle appears to this court to be a serial property criminal. His record speaks for itself. And for somebody who comes before this court and says he never really meant this to happen, He has stolen so many times, on so many occasions, and been convicted in so many courts. The court finds it difficult to accept. The court just simply will follow the presumption of prison in this case. This court has imposed a mitigated sentence, at least partially in response to the defense arguments made in the case. The court will order the defendant to serve the mitigated sentence of 11 months in Department of Corrections custody. Again, he will have a 12-month post-release supervision period, 20% of good time credit, as announced before. The court will assess a felony docket fee in this case. However, waive all bids assessments in light of the court's incarceration order. Regarding the issue of jail time credit in this case, the court finds the defendant has served 26 days of accrued jail time credit to be reflected by the journal entry stemming from today's proceedings. There does not appear to be a request for restitution. Am I correct on that, Ms. Norris?
That is correct.
Right, thank you. Some point in the future, Mr. Weedle, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those to a lawyer and I'm sure get your questions answered. Under some circumstances, a criminal defendant in Kansas has a right to appeal their conviction to an appellate court having jurisdiction. And if they are unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, a defendant has 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. Mr. Weedle, you do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged.
Can I say one more thing, Your Honor?
You may.
The only reason why I pled guilty to this was because my attorney told me to. He told me that I was going to get probation and stuff, and that's the only reason why I went through with this to begin with. I should have just took it to jury trial to begin with because I didn't steal it. I simply found the phone outside. Like I said, the only reason why I pled guilty was because he told me to. He said I was going to get probation, and that's why I wanted to get it over with. I didn't think I was going to plead guilty to prison. I mean, the ones I got in Sedgwick County, when I first caught this case, I wasn't on probation corrections or nothing. It should have been a probation case. So I don't understand how it's a felony case now.
Well, I'm not going to worry about what happens to you regarding your Sedgwick County cases. I'm focused only on this Butler County case in which you've entered a plea to and accepted conviction for. The court has denied your departure request. You are presumptive prison in this case. The court is simply following the presumption which applies in this case and ordering the prison sentence. So the court will demand the custody of Mr. Weedle to the Butler County Sheriff's Office and the jail until his custody can be transferred to the Department of Corrections to serve the remaining balance of the 11-month sentence earned here today. Mr. Weedle, I would just suggest to you that you take advantage of any program offered in the Secretary of Corrections custody that might enable you to not only earn the maximum amount of good time credit, but also help with rehabilitation so that you don't have to appear back before courts facing any more charges like this in the future.
I got locked up February 23rd. I don't get those credit days that I did in Sedgwick County that had a no bond on. I could have bonded out in Sedgwick County, but I couldn't because you had a hold on me. So I've been locked up since February 23rd. So I should have over 60 days of good time.
Ms. Norris, has your jail time computation taken this into account?
No, Your Honor. He appeared in our jail on on April 2nd. I don't know anything about the time that he spent in Sedgwick County. He had one day on the original PSI from back in, looks like August of 25, and then he appeared in our jail on 4/2. And then I counted up to today's date, so that's the 26th. I don't know anything about the Sedgwick, whether he was in jail in Sedgwick County or not. I just went with what I know from our jail when I was giving the court information.
Yeah, I was picked up on February 23rd.
Judge, I think, as Your Honor is well aware, he'd be entitled to that time in Sedgwick County if he was being held on this case alone, pursuant to or prior to being moved over. I just
I
don't know how
was.
many that would be.
Well, I don't understand why they held on to him for so long.
Because I had a felony hold. I had a hold here. You had a hold on me. I couldn't get out. I could have bonded out in Sedgwick County, but you guys had a hold on me, so I couldn't get out.
But Judge, I think the appropriate question is, at what point was Sedgwick County done with him? At the point where his Sedgwick County cases are over, and the only reason he's being held over there would be this case, he would be entitled to credit on that case, on this
I would
case.
agree. If the only reason he was being held was because of a Butler County hold, then he's entitled to Butler County time.
And Your Honor, I would agree, but I highly doubt that that's the case, that he was being held on this case only. I can look into it and see what we can find out for purposes of the journal entry, but I do know for sure that he has 26 days as of today's date in our jail on this case.
All right, I would just ask that there be appropriate research in that regard, and that he is entitled to the appropriate number of jail time credit days. And I want to make sure his eventual sentencing journal entry reflects the full number of jail time credit days to which he's entitled.
Your Honor, if I might add something.
Yes.
I can tell from our system that we can see he was arrested on his Sedgwick County warrants on that February 23rd date.
Sounds like Sedgwick County was the one that was holding him.
But I could have bonded out on them. But I couldn't bond out because you guys had a hold on me, so I had to sit there.
Well, I would just want to make sure that any current jail time credit rules that would apply to his situation are applied to make sure that he receives the number of jail time credit days to which he's entitled for this case.
When we're done, Your Honor, I could do a brief meeting with Mr. Weedle, determine whether or not he wants to file an appeal.
I do, sir.
Okay, well, that answers that question. I will file an appeal on your behalf.
Very well, then. Do you not need the breakout session with your client then, Mr. Watts?
No, Your Honor, I wanted to make sure that his decision on appeal was noted and make sure we get it filed.
All right,
Timely.
very well. Ms. Norris, anything further we need to address here?
No, Your Honor, thank you.
Very well. Then if there's nothing further, the Christopher Weedle matter will be in recess at this time, and this meeting may be ended for all.